one moment, Ms. Kaufman, if you will. Right.
Good morning, my lords and my lady. I appear on behalf of the appellant, GLP, together with Mr. Barrett.
You may have to speak up a bit.
I am sorry, I will make sure I do. Together with Mr. Barrett, Mr. Paynes and Mr. Hogarth. And the respondent is represented by Sir James Eady, Christopher Knight and Ruth Kennedy. I'm so sorry. I completely forgot to note down everybody's names. I'm terribly sorry, Miss Kennedy. I'm terrible with names. My lords, my lady, if you'll indulge me for a few moments, I just want to say some words by way of introduction, because there are...
Can I say something
Yes.
by way of introduction? You will have received an email from me yesterday, to which you both responded, in which I disclosed what I would imagine is pretty well known, that I am mentioned, my office is mentioned quite a lot in the PRA, the Public Records Act, and I just drew that to your attention in case anybody hadn't noticed that I was the chairman of the Advisory Council on National Records and Archives under the legislation which we are dealing with today, and asked the parties whether they thought that meant that I should not be sitting on this appeal, and the answer was, I think, no. But I just wanted to record that for those who are looking on the live stream and in court this morning. So I am sitting on this appeal. But I mean, the reason I raised it is because, of course, I do have personal knowledge, chairing the ACNRA, of the way in which this process works in practice. Actually, what the ACNRA does is probably not relevant to the issues in this case, but it does enable me to have an insight into what goes on in Kew in the National Archive and how the engagement with government departments occurs.
Indeed.
Just to make that clear. Your introduction.
So the reason I want to say something by way of introduction is because I would like the court to keep in mind throughout that there are three important public interests that are engaged in this appeal. I want to say a little bit about the first, and then also to signpost for the court where I'm going to go in relation to the second and the third. And the first matter of public interest, an important matter of public interest, is government accountability in this modern age of electronic communications, be it email, be it WhatsApp, be it Signal, or whatever other applications enable instant communication to be conducted between individuals. And specifically, it concerns the use by ministers and government officials of private communication systems and devices in the conduct of government business. And the reason that this is a matter of importance and public importance is because such use has implications for security, for transparency, and for accountability, among other important public interests. So that's the first matter of public interest, and that's the immediate subject matter of the challenge. But then there are two other important matters of public interest that relate to the nature and scope and the reach of judicial review, and thus also the accountability of government through the supervisory jurisdiction of the courts to the law and the rule of law. And the first of those is with respect to the use and application by government of policy making, and specifically the nature and scope of the public law duty to comply with existing government policy absent good reason to depart. And the second area that is the concern of judicial review is with respect to the rules of standing. those rules by which individuals can bring for adjudication by the courts challenges to decisions and decision making on grounds that the decision maker has acted contrary to the principles of public law. Can I start with some brief observations on the first issue, the public importance of a transparency, accountability and security in relation to the use of private communications. Now, as your lordships and my lady will have seen from the papers, this issue arises in the context of the government's own policies. There are two kinds of policies with which the court is concerned with this challenge. One are policies relating to information management, policies governing the generation, the recording, the preservation of records concerning the conduct of government business. And the second category are policies relating to, or a particular policy, the security and government business policy, relating to the security in, or issues of security in relation to the conduct of government business. The appellant's case is that it is the government's own policies that firstly prohibit the use of private communication systems, and secondly require that in exceptional cases where such communication systems and methods are used or are permissible, those who have generated information through those communications should proactively transfer the material, substance of the material, into official government repositories. And our challenge...
All the material?
Not necessarily all the material, but we'll see that some of the policies certainly contemplate that where that material relates to the substance of government business, then yes, there should be a transfer of, for example, if it's WhatsApp, those messages.
That answer makes it rather difficult if you accept that if there is a communication about what time you're going to arrive for dinner.
Oh, no. It's about the substance of government business. So one has to distinguish what is the nature of the information that has to be captured from the information that is merely ephemeral and doesn't have to be captured, and then what is the mechanism of capture and preservation. So they're separate questions.
So, Mr. Cleft, sorry to ask you a question, but I just want to understand what your case is. Is your case that the government's policy absolutely prohibits the use of private communication systems, or is it your case that it prohibits it with a recognition that there might be exceptions where those methods might be used?
So the terms of the policies prohibit it, but
Right.
as a matter of public law, the legal enforceability of a policy includes that the policy can be departed from for good reason. So our case is, the terms of the policy prohibit it, but as a matter of public law, you can depart where there is good reason so to do.
All right, that's very helpful, thank you.
And the challenge is that the government itself, or the officials, ministers, the Prime Minister, in certain instances, have failed to comply with one or both of these requirements of their own policies. Now, part of the purposes that these information management policies serve, and which these prohibitions also serve, is, as I've mentioned, ensuring the government is accountable to and transparent with the public in what it does. And as we shall see, this obvious but nonetheless important fact is something that is repeatedly and unsurprisingly recognised in the policies themselves.
But may I ask a further question,
Yes.
please? What remedy are you actually asking the court to give you?
A declaratory relief.
Declaring what?
Declaring, firstly, the principle that as a matter of public law, these policies are subject to a duty of compliance, absent good reason for departure, and a declaration as to the breaches, if any, that the court finds arose on the facts of the case.
Well, if you're asking for relief from the court, it's customary to set that out in writing. And I've been surprised in looking here for a draft order or any clear note of what you seek from the appeal court. And I'm afraid you will have to do that, Miss Kaufman.
We will do that.
And quickly, please.
We'll do that. We'll make sure that by tomorrow morning, the court has exactly that.
Sorry, just whilst on that specific point, you say, and a declaration that relates to the breaches of the policy by the ministers.
Yes.
And that was completely lacking from the amended statement of grounds. I mean, one might have thought when you started reading the amended statement of grounds that it was all going to lead to a schedule of breach X, Y, and Z, but none of that's there at all. Is it fair to ask for that sort of relief for the first time on appeal?
Can I come back to your lordship?
Of course,
on that?
yes.
Can I consider this question overnight and come back with a clear position on what relief we are seeking? My initial response is yes, it would be, because what will certainly happen in the course of today is it will be made absolutely clear how we put the case and what breaches we consider there have been. And in light of that, we can draft the relevant relief. You'll have seen the respondent's position on this is that insofar as the court is with us on the law, then the question of breach should be remitted back to the administrative court on the basis that none of this was determined at first instance because of the finding that the policies were not enforced.
And you say that shouldn't happen?
We can see the sense of that, but we submit that there is a way through that avoids the need for such a course to be taken and avoids the expense. That is, that we submit that this court is in a position on the material before you, and that is on admitted or on the defendant's own evidence, including its answers to requests for further information, that it is clear what happened, and if this court concludes that what happened was a breach of the policies and unlawful, then the court can make that decision.
Well, facts are not found on judicial review cases generally anyway.
No.
So it's either what they say or nothing.
Exactly. So on the basis of what they say and what we don't in any sense contest, we submit that it's possible for the court to make that finding. Can I deal with that when we come to relief, which I'll come to obviously at the end of my submissions today?
Yeah. And you have agreed a timetable with Sir James, have you?
We have indeed, and I'm going to take all of today.
All of today?
I believe so. It may be quicker. I never know. Depends on the number of questions I get. But I will be done by today, and I imagine Sir James is not going to take as much time as I am tomorrow, so we will certainly be finished within our allotted timetable.
Thank you.
So, yes, so, and as the policies themselves make clear, I was talking about the public interest the policies serve in transparency and accountability, and that this is repeatedly stated in the policies themselves, but they also serve a number of other public interests which themselves also serve that, as it were, higher level public interest of transparency and accountability, such as the public interest in securing compliance with the statutory obligations under which these ministries and officials operate, such as the Freedom of Information Act and the Public Records Act. The respondents submit that we, the appellants, are being wholly unrealistic in what it is that we are arguing for and the findings we are seeking the court to make. And this is on the basis that if we fail to acknowledge the way modern communications operate across society and therefore also within government as a necessary part of society. And in response, I come back to the fact that the appellant is seeking to do, in this case, no more than hold the government to account in respect of its own policies. That is, in respect of its own assessment of how such communications should be used in the conduct of government business, and how and where any information so generated should be recorded and stored.
Do we not see in these policies a progression as technology is developed? So do we not see a sort of element of change as people's usages, general usages of electronic communications has changed? So policy may have started with, well, you really ought to use only government communication devices, and if not, send them to a government repository. Over time, people realised it was quite unrealistic. Ministers have their own phones, they have party political business, they have constituency business, they have to communicate with people of all kinds and stripes in relation to all kinds of things, and they need to be modern people. So there are allowances and carve-outs made, and we see this in the policies. To say they're legally enforceable when they're changing in that way is difficult, isn't it? I mean, just as a matter of practical reality.
Well, policies don't cease to be legally enforceable because they're changeable. It's a fundamental principle of public law that a policy has to be something that can be altered, whether it has legal force or not.
Well, I mean, that depends on the policy, as the divisional court said. But here, what seems to have been neglected, anyway, to me, is the actual terms of the Public Records Act. The Public Records Act, you don't seem to place any reliance on Section 1 of the Public Records Act, which for my part seems unbelievably important. And the role of the keeper, which is extensively set out, provides that the keeper is to give guidance under Section 3.2 in relation to the duty under Section 3.1. So, yes, there is statutory guidance here, but at the moment what I don't really understand is where it all leads. You know, you say you want to hold the government to account, but your main complaint is that they use private emails. Well, everybody acknowledges that people can use private emails.
Well, I'm going. What I
form.
hope to do, my lord, is to take your lordship through the policies to show that yes, they've developed over time, but not to a point where they permit the use of private communication systems. So that's
Ever?
step one.
I mean, ever, if you're a minister?
Yeah, that's exactly what the security and government business policy makes absolutely clear. And there are
Depends
other
what
policies
for,
that do
doesn't
so.
it?
You can always, in public law, do something that is not compatible with a policy where there are good grounds to do so, where there is good reason to do so. So public law does not operate as an absolute constraint. It would be incompatible with the discretion that is conferred for public law to develop such principles. So the mechanism of holding the government to account to its own policies is one which takes into account that need for flexibility. So if a term in a policy is absolute, public law will not judge the legality of any conduct that departs from that policy by reference to the absolute terms. It will judge it by reference to whether or not there's good reason to depart. So yes, we start by looking at the terms of the policy. Then we have to look at what the nature and scope of that duty of compliance with policies is, and does it apply to policies of this kind? And if it does, then the government is free to depart.
Isn't there a difference? I'm sorry, I'll shut up. But isn't there a difference between a policy that is made under this legislation, which is the legislation you rely upon, which is the policies made by the keeper, the guidance given by the keeper under Section 3.2, and some guidance given to the Department of Health and Social Care and any other departments, all of which must have loads of guidance about their own situation. I mean, doesn't seem to be any distinction. I mean, why are we looking at the Department of Health and Social Care and not at the 15 other departments?
Oh, well, it may be that the 15 other departments are also doing this. The reason this has come to light is because of matters that came into the public domain as a result, firstly, of leaks by Dominic Cummings of blog posts, which made it quite clear what communications were going on. And then there were other matters that came into the public domain through litigation
But I mean, the point I'm making to you is that the Public Records Act has not got anything specifically to do with whether ministers use private email. The public...
No, the question in relation, if your lordship will let me develop the argument, I hope that it will answer your questions as we go through, as to how we put things as we do, as to the relevance of the Public Records Act. I am very content to put this case on the basis that the Public Records Act is neither here nor there, that this is a third power, that this is a third source of power. It's a common law power, or it's ancillary to the Public Records Act, ancillary to the Freedom of Information Act, but it is nonetheless a public law power subject to...
I'm not sure you can introduce a claim like that at this stage.
Well, we've made it in our skeleton argument. We've said if it isn't done pursuant to the Public Records Act, then the Public Records Act certainly empowers it to be done. It may be done, and we will look at third source powers. My lord, if your lordship will let me develop the arguments, and then if your lordship believes there's something here that I shouldn't have introduced or I shouldn't introduce, can we deal with it
I'm
as we
sure
get
Sir
to it?
James will be very quick to pop up if he thinks.
Yes, I'm sure he will. So, and it must not be forgotten, the security and government business policy is not a policy made pursuant to the PRA. We don't argue that it is. We make it very clear in our skeleton that this is entirely separate from...
So which one is that?
That's the security and government business.
That's the policy that we don't have any text of. It's just summarised and referred to.
We have some of the text. We have some of the text because we are not permitted to see the policy because, for obvious security reasons. But we submit we have sufficient of that text to see that it's in mandatory
but how
terms.
can you possibly know whether you've got enough of the text to be able to make decisions
Well, again,
about what it means?
Can we look at it and then we'll see? And that's obviously going to be a decision for the court as to whether it meets the requirements of constituting a policy in mandatory terms. So,
So page 379.
yes, we will. We're going to come. Following this introduction, I'm going to take the court through the relevant policies so that the court can see exactly what they do and don't require. So, as I stated, the basis of our challenge is the terms of the respondent's own policies. So, to the extent we are being unrealistic, that is only because the government's own policies are unrealistic.
I mean, just to get some architecture to this case, my understanding was that there were 4 matters for the court to determine. 1, the proper construction of Section 3.1 of the Public Records Act. 2, whether the Divisional Court was right to say that these policies, the relevant policies in this case, were not enforceable as a matter of law. 3, whether the done note was unlawful. And 4, whether you had standing. Now, if you are going to pursue another route through your case, just explain to me why.
So I'm not pursuing another route through the case. One route through the case has always been third source powers, because the security and government business policy is itself a third source power. A third source power. So there are powers conferred on government by statute, powers which arise as a matter of the prerogative. And then there is the question of the existence of other powers, which are powers that inhere in the common law.
So can we look at your grounds of appeal and see where it is in the grounds of appeal?
Well, we address in the grounds of appeal that the SGB policy is not itself a policy made pursuant to the Public Records Act. So if it isn't made pursuant to the Public Records Act, it has to have another source. And what I was intending to do is to take the court through very quickly, some of the case law on third source powers, which establish that third source powers are subject to judicial review, just as the prerogative, just as statutory powers are.
I mean, just for the record, I don't really see that in paragraph 1 of your grounds of appeal, which I think is the only one in which I could see it. I mean, it's at page 12 in the core bundle, and it says the court's finding that the policies in this claim are not enforceable as a matter of public law 102-109 was wrong and defective for lack of reasons. The court did not take account of the specific statutory context in which the policies arose, which, as I understand it, is the NRA, and the reasons given for the court's conclusion were wrong in law. 110 to 115. So where do we get the third source power?
Sorry, my lord, can you take me back to those paragraphs? I was just having trouble getting my
It's
computer.
page 12 in the core bundle.
Yeah.
It's, if I may say so, an extremely concise and much to be commended, the grounds of appeal, because they are concise and clear, but they don't give you as much wriggle room as you perhaps are now seeking.
Yes, I can see that it isn't there. It's there in our grounds from the beginning, I think. In our
Yes, but we deal with grounds of appeal. You know, I mean, there has to be some. I mean, the four issues I put to you really are very clear on the face of the skeleton.
yes,
Yes.
and this issue fits within those four issues. It's
Okay.
not. It's a necessary step, unquestionably, in relation to the security and government business policy, which we have always pursued on appeal as establishing a duty to comply with its terms.
Well, let's leave it at this. You know the way I, speaking only for myself, see the architecture of the case. And if you're going to take that beyond what is in the grounds of appeal and what I've said the skeletons reveal as the issues for decision, you're going to have to explain why that's appropriate.
I will indeed do that.
Okay.
So perhaps what I should do now, given where we are, is to move on and get into the meat of the argument. I just want to briefly outline for the court so you know exactly where I'm going.
Yes.
So we're going to look now to the terms of the policies. We're then going to look at the facts of what action were taken by various government ministers and officials that we submit are inconsistent with the requirements of those policies. And we're then going to move on to the legal source of those policies. So that's when the PRA construction comes in. It's also when the third source powers come in relation to the SGB, and or in relation also to these policies.
Do you need to say more about the SGB than that it is a government policy and it's part of your argument for saying that the done note is unlawful?
I'm going to come right through to why we say that policy is subject to public law principles. I have to make good the argument that the divisional court was wrong. So if I need to establish...
I'll try to help you.
I'm sorry, I need to establish that that is a policy of the government, that is a policy which has been established in the exercise of a third source of power, and that third source of power is subject to principles of judicial review. I need to establish the terms of that policy and that they prohibit the use of private communications. And I need to then move on to establish that as a matter of principle, judicial review includes as a ground of challenge a failure to comply with policies on the part of those who are responsible for making them, and that extends not only, as the divisional court found, to instances where the policies touch upon the deprivation of liberty.
The point is that the done note and the SGB policy are inconsistent, which is, I understand it, your argument. How's the court in a position to adjudicate on the question of which of the two inconsistent policies should be preferred?
Well, one remains in force, and insofar as it remains in force and is inconsistent with the later one, then that settles it. You can't have two policies in existence that are in contradictory terms.
Right.
So, but we'll come to that.
All right.
Dunn's right at the end before I get to standing. So we will look at third source powers, but I will submit that ultimately, for reasons I'll develop, the source of the power does not matter. They're all subject to judicial review. Then I'm going to address the duty to comply with policies, and that then is going to take us into some deep water, which does throw up some questions of the nature and justification of judicial review itself.
So what's going to take us into deep water?
It's going to take us into deep water, some deep water.
What is?
The question of the nature and scope of the principle that a decision maker must comply with their own policies. Because it will throw up questions, and it does throw up questions about the nature and justification of administrative law itself. And then I'm going to address the legality of the departures in light of what we submit is the proper scope of the duty to comply. And finally, I'm then going to look at standing and submit that both the course taken by the court in Runnymede and the course which the respondents are arguing for in this case risks leaving swathes of executive action or executive unlawful action immune from challenge for want of a suitable challenger in future cases. And will put forward or seek to restore the orthodoxy established by the Supreme Court in two key cases, AXA and Wilton, which we'll look at. So can we look at the policies to begin with?
I would ask you not to drop your voice at the end of a sentence. You named two cases there I didn't hear.
I'm sorry.
What are the
Keep
two
reminding
cases?
me, I'm so sorry if I do drop them.
Yeah, no, because it's difficult. We have quite a lot of competition from the street.
I will try to remember to keep it up, but please do
Thank
tell me
you.
if I
What
do.
were the two cases you mentioned?
So Walton and AXA, and we will look at both of those. So starting with the National Archives Records Collection Policy, and that is in the supplementary bundle. It starts at page 241.
Now this is the policy that the divisional court said was not a statutory policy, and you say is a statutory policy.
This is a statutory policy. This is a section 3.2 policy.
Right.
Because it is a policy by the National Archives, from the National Archives Office, and it's about the collection of records and the preservation of records. So it's clearly a section 3.2 policy. It says at paragraph 1, this guidance on the management of private office records is drafted in terms of... oh, sorry, I'm looking at the... I'm so sorry.
Well, I think you've got that wrong.
I'm now looking... I've just gone to the wrong... So the National Archives Records Collection Policy starts at 241. And if your lordships and my lady turn to page 246, section 3.
Right. So this was accepted as a statutory policy by the court.
So 246, section 3, which records should be selected for permanent preservation? And in the second paragraph, public records can exist in any format, including paper, digital, audio, film, or model format. They may be in any medium, including social media channels, and they may have originated in private email accounts, not only in the government's own systems. And then at 3.1, we get criteria. The National Archives seeks to collect and preserve public records which document, 3.11, the principal policies and actions of the UK central government and English and Welsh governments, including records illustrative of the process of developing government policy and legislation. And then if you move down, 3.1.2, and also the structures and decision-making processes in government. So we've got these two overarching kinds of records, and then within 3.1.1, records illustrative of the process of developing government policy and legislation. Can we then move to the Cabinet Office, National Archives, Management of Private Office Papers Guidance? That's at page 212.
Can just before we leave this one, can I just ask you on page 241? I infer that this was first drafted in 2012. Do you know any different? And I say 2012 because it says Crown Copyright 2012, and then last reviewed on
Last reviewed in October 19. I don't know any different to that. That's
Okay,
exactly what
sorry to interrupt.
I also assume. So the next policy is on page 212.
And this is the one that the court said, the Divisional Court said was non-statutory, and you say is statutory.
And we say is a policy made under section 3.1. Yeah.
B2. Guidance.
Section 3.2. 3. Bear with me.
So on the bottom left-hand corner on page 212, it
No,
says...
section 3.1. I'm sorry.
Sorry. Page 212, bottom left-hand corner, it says Cabinet Office / the National Archives.
Yes.
So do we infer that this is a document produced jointly by the Cabinet Office
Yes.
and National Archives?
So it will be a 3.1 and 3.2 piece of guidance. So far as the
But the 3.2 says every person shall perform his duties under this section, under the guidance of the keeper of public records.
yes. So that is guidance made by the keeper, but it's also guidance made by the Cabinet Office, and therefore section 3.1 applies.
Yes.
It shall be the duty of every person for public records of any description which are not in the Public Record Office or in a place of deposit appointed by the Secretary of State under this Act to make arrangements for the selection of those records which ought to be permanently preserved for their safekeeping. Now our submission is, because we submit that these provisions concern not just the actual final selection for permanent preservation, but also, by necessary implication, the selection and preservation of records to be later subject to that selection process, then this is guidance of exactly that kind, i.e. section 1 and section 3.1 and section 3.2 guidance. But if you can, this applies to all the respondents in this case, and it identifies all the records that are required to be stored in respect of ministers and their private offices. And if the court can look first at paragraph 1, and paragraph 1, paragraph 3, 4, and then first 4 lines of 5, and then and then at page 215, sorry, the bottom of page 214, there's a heading Records Covered by the Guidance. Records of the following categories are likely to be covered by this guidance. Well, can I just ask the court just to look at 3 and 4 above that heading, Records Covered by the Guidance, and we can see that the purposes of these information management policies, this one is to ensure accountability, providing an audit trail which relays the views of the minister to the appropriate policy area and allows records to be identified for historical and research purposes. So it's plainly, and as many of these policies themselves say, aimed at ensuring that the Public Records Act duty to preserve records and create a public record for historical and research purposes and other purposes can be secured. So it then addresses the records covered by the guidance, and we can see at 9 it includes records of discussions using instant messaging. And then at the heading just above paragraph 11 on page 215, we can see the events which need to be recorded. The records that need to be created by the private office will largely be concerned with the meetings and telephone conversations relating to official business that take place during the normal course of the minister's day. In general, records should be created of all meetings, events which take place with ministers and or officials present where decisions are taken on departmental or government policy and or, this is important, and or there is follow-up, follow-up action required, or where views are expressed which would be helpful to the work of those not present. Records should be created to cover, among other things, and if the court could read 3, little Roman numeral 3, and 4, and then under the heading events which do not need to be recorded, above paragraph 12, in some instances meetings will be purely informal or of a social nature and no record needs to be created. Before we leave this, I just want to check that I...
And then there's an express exception in 12 little Roman 3 for telephone conversations, meetings that are not a formal discussion on matters of policy, but which allow ministers or officials a confidential space within which to develop ideas or respond to fast-moving situations.
Indeed, exactly. So that's clear in the policy.
Might not be so easy to distinguish on the facts between something that falls within the exception and doesn't.
That may or may not be the case. And ultimately it's going to be a matter of judgment.
Yeah.
In the first instance, by the person who's responsible for having those discussions and recording them if they take place. And can I just go back to paragraph 7 to make sure that I've covered that? I'm not sure I asked the court to read that.
You didn't, because I've got a note of what you did. You're right. So.
Yes. So I should have done, and it makes clear. Page 214, private offices should adhere to the records management policies and practices adopted by their department, and such policies and practices should include procedures specific to private offices. So it's making clear that they need also to adhere to their own department's policies.
Now, is this guidance addressed to officials in private offices?
Yes, because the
Telling
definition
them,
of minister is at paragraph 1.
telling them what to do in order to create these records. Is that right?
This is applicable to, in paragraph 1, in terms of ministers, but it also includes permanent secretaries. And
is there an apostrophe missing from ministers?
I'm not sure there is, no.
Well, otherwise it's difficult to make sense of the sentence.
It's drafted in terms of ministers, but it also includes permanent secretaries' offices.
I see.
And it applies then to all information created of any medium. So it applies to the communications of ministers themselves.
One potential reading is that this applies to records created in ministers' private offices by civil servants, and also to those records which are created by civil servants in permanent secretary offices. Is that a tenable construction?
In my submission, no. It applies to the need to create records in
So
respect of
ministers
certain
need-
types of communication.
So a minister, are you saying that ministers are required to create records?
It may not be the minister who creates the record, but in some instances, yes, absolutely, the minister is required to create the record. So,
Right.
for example, if there is a communication or private WhatsApp communication, that would have to be created by the minister themselves,
Okay.
because nobody else has access to it. In most instances, this policy, because, well, this policy doesn't deal with private communications, but it certainly, one can see, assumes there won't be such private communications, and certainly what it appears to contemplate is that it is going to be officials who are going to be responsible for creating the record. That makes sense. If everything that is happening through official government channels with the presence of officials, then it will obviously fall to the officials to have the job of creating records. But that isn't the case necessarily if private communications take place. So, can we now look at policies that actually concern? So these policies concern the ones that we've just looked at, the kinds of records that need to be created. Now I want to turn to look at policies which concern the way in which communication is conducted in relation to substantive government business. And this is where we come to policies that prohibit the use of personal devices. So the first is the security and government business policy. Now, as my lady noted, we do not have the actual policy because it's been withheld on grounds of security. So all we have are citations from, direct quotes from those policies insofar as they are relevant to this case. And those are
this policy has nothing to do with the National
nothing
Records
to do with the National Records Act. So Sarah Harrison, one of the defendants' witnesses, has prepared a statement, and at page 119, she addresses security and government business. I hope that's going to take you to paragraph, yes. So if the court would read from 50, I would imagine, so security of government business, if the court would read from 50 down to 57.
Paragraph 51 suggests that ultimately this is to do with complying with the ministerial code, and that's a question for the Prime Minister. Is it a question for the court?
Yes, and we're going to come on to that, my lady. We will be looking at some case law relating to that.
And 57 confirms that it's nothing to do with the PRA.
Yes, absolutely nothing to do with the PRA. So, but your Lordships and my lady will see the terms in which the use of private communications is dealt with.
Yes.
And they're very clear, and they are mandatory, and it's made absolutely clear that compliance is a matter of government policy, and that there may be repercussions for non-compliance. So it is in mandatory terms. It's not issued under the PRA.
I thought she said it's advice.
She describes it as advice, but ultimately that is a matter for the court. as to what its terms, properly construed, require and mean. And it says, as I have just indicated, in the clearest terms, that a failure to comply contravenes government policy. Now, that is not advice. Can I also, just for the court's pen, it doesn't directly arise, but just note that there are...
Contravening government policy unlawful?
Well, that's a critical question in this hearing. That's one of the issues, one of the key issues that the court is going to have to determine. Our case being that a failure to comply with the government's own policy is unlawful in the absence of good reason to justify that departure. And we submit that is a general principle of public law, not one limited, as the divisional court found, to cases where the liberty of the subject
That's the point. But I mean, even you would accept the answer to that question is maybe. The answer to my latest question is maybe. Is it unlawful? It may be. And you say it is here.
Exactly. We say no good reason has been shown. Exactly that.
Well, not just no good reason. I mean, you accept there are some policies issued by government which it would not be unlawful not to comply with, don't you?
Indeed, there are some policies there are some policies which are not framed in such mandatory terms. They're framed in a manner that gives a discretion to the decision maker as to how to.
No, but is it just a question of framing, or is it to do with the substance?
So,
I mean, the divisional court said it was to do with the substance.
Absolutely, and we submit that the divisional court is wrong to conclude, as a matter of substantive judicial review or administrative law principles, it is wrong to conclude that the principle which establishes a duty of compliance with policies is one which is limited to cases where the liberty of the subject is at stake. That's the key principle that is in issue in this case.
Yes, but what I was putting to you was, you don't say that all policies have to be complied with, even if they're in non-mandatory terms, or even if they're in mandatory terms. There must be some other limitation on when it's unlawful.
So, the principle of compliance, if I can call it the principle of compliance,
yes.
The very nature of the principle of compliance is in non-mandatory terms. It recognises that there can be lawful departures from a policy which is in mandatory terms. So one has the clearest of policies, as we say this is, you shall not use your private devices. Even a policy such as that can, as a matter of public law, be departed from if there is good reason. That is the principle. So the principle includes within itself a justification for departure, or a possibility of departure, which is lawful.
I mean, is that consistent with the Supreme Court's decision in VA?
Yes, it's entirely consistent, and it's just the nature of the principle. I don't think there's any dispute between us on the nature of the principle. I think the dispute between us is as to its application. The respondent's case and the divisional court's case was, this principle has no application to policies of this kind because it is entirely limited to policies that determine the liberty of the subject and perhaps
Well, it's not limited to policies that determine the liberty of the subject, because I mean there are plenty of examples of policies that people issue, I don't know, to all kinds of, say, local authorities, and the rule that they should comply with their policy unless they've got a good reason for departing from it is pretty general.
Yes, well, that's...
But they're usually policies that have some effect on people outside the organisation.
Well, this does, in our submission, have effect on people outside the organisation. It has effect on the public in general. These all have effect on the public in general. We'll come to that. It's critical. It's a critical part of my argument.
I thought you said, or I thought the divisional court said it was limited to policies concerning individual rights. And you
Individual
challenged that.
rights, and perhaps, yes, I would, it was too narrow. Individual rights, of which the liberty of the subject is an example.
Yeah.
And perhaps incrementally they say instances of where an individual is benefits, might benefit under the policy as opposed to have an actual right that is touched upon or engaged by the policy.
You say it applies to much broader than that, to anything that affects the public.
To anything, yes. To an exercise of public power in the sense that it is an exercise of a power that is done in the public interest, a true governmental function. That is our case, and I will come on to exactly why we say that. So, that's the security and government business policy. Can we next turn to...
Could you just help me with where in your skeleton you describe those words? I say it applies to anything that affects the public in pursuance of a true governmental function. I need to see that written down in your words, not in mine.
My junior will pull that up. Can he pull that up whilst I continue? So next, can we look at a policy which applies to all ministers and officials at the Department of Health and Social Care, and that's the DHSC Information Management Policy. That's addressed in the judgment.
So we haven't looked at this SGB at all.
Sorry?
Even at the extracts. We haven't looked at the extracts of the SGB.
We don't have them.
No, but we have at page 379 to 380. Don't we?
We've got extracts which are from another statement, but actually they're no different from what I've just taken you to in Ms. Harrison's statement.
Thank you.
I thought Ms. Harrison was slightly fuller in her explanation, so I thought it was better to take you to that. So page 264 is where this policy starts in the supplementary bundle, and there's an executive summary at page 266. Could I ask the board to turn to that? Executive summary. This document sets out the information management policy of the Department of Health and Social Care and outlines what it means for work groups and individuals. Staff working within the department are required to store and transfer, this is the third bullet point, information securely, and then 5, proactively manage information through to its destruction.
You said this applies to ministers. Where does it tell us that it applies to ministers? I must say I'd read it probably rather quickly as simply applying to officials.
I don't think it's in dispute that this applies to ministers, is it?
Well, I don't know, I'm just asking the question. If you look at page 273, at the top of page 273, there is this question: who does the policy apply to? It applies to everyone working in the department, whether employed as civil servants or engaged as consultants, blah, 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 blah. I don't see a reference to ministers there. I'm simply asking.
Well, I mean, a minister is working in the department.
The textual language. Oh, you say a minister's working in the department, okay.
When a minister works in the department, a minister heads the department, and the most important records that are going to be created are ones which relate to ministerial decision making and the processes of that decision making. If we could go back to page 266 and the policy of the executive summary, so they must, the 5th bullet point, proactively manage information through to its destruction, and then all staff must familiarise themselves with the information management policy and ensure that they abide by these principles, which are described in more detail in this document. And then if we can go to page 276 and compliance. Under the heading compliance, the 2nd paragraph, failure to act in accordance with this policy means that we may not meet our responsibilities in managing our core business of supporting ministers' policy development and public accountability. In certain cases, this may expose the department or an individual to legal action. And on page 285, organising information so that it is accessible, can be located and is available for reuse. And then we have using DHSC information systems. And if we get under the heading email, and the bottom paragraph there, you should not use a personal email account for business conducted on behalf of the department. Auto-forwarding of emails is not permitted and is disabled in open source service. Any exception to this rule is in exceptional circumstances only and requires the agreement of the DHSC information and security team.
Sorry, that last page reference again?
That is page 285 and it's the bottom paragraph. And then on page 286, you are required under the Public Records Act to save emails that are needed to demonstrate decisions, actions, and use of resources for the record. Such emails should be placed on the Records Management System information workspace. So there is a place, a repository, an official repository where records need to be stored. And then we have the heading, Information Workspace and Shared Drives. The department's policy is that material, the department's policy is that material that needs to be retained for the record should be stored in the information workspace if the format of the material is able to be placed there, i.e. is it electronic, and so forth. So we have the witness statement of Lorraine Jackson, which addresses this statement. That's at page 63.
You mean this policy?
Sorry, this policy.
Yeah.
Thank you. I'm sorry. She starts at page 63, paragraphs 15 and 16. And she says in terms, the information management policy was not developed envisaging the use of private accounts or devices. The policy assumes that departmental work is conducted on DHSC devices. This is reflected in the fact that it further states that neither personal My Documents, nor desktop drives, nor personal mailboxes should be used to store information needs to be retained as part of the official record or shared with others. And then if you could turn to page 66, paragraphs 31 to 32.
Sorry, which paragraph?
Page 66, paragraphs 31 to 32.
Thank you.
DHSC arrangements for selections of records for retention, arrangements for selection. I understand that section 3.1 of the PRA requires DHSC to make arrangements for the selection of public records which ought to be permanently preserved for their safekeeping. And then next paragraph, in order to enable these decisions to be made, the information management policy sets out how records should be captured onto corporate systems. And at page 23 it states, and that we've just looked at that particular guidance, and she says at the bottom, in respect of that, at paragraph 33, this wording was chosen to stress to members of staff and ministers that it is important to, and we can see staff and ministers, so her understanding certainly is it. And apparently the last, thank you very much, the last sentence of paragraph 10 says in terms that it applies also to ministers.
Right, that's helpful.
So this wording was chosen to stress to members of staff and ministers that it is important to retain evidence of substantial government decisions on the information work system. I accept that this is not the language of the statute itself, but it was drafted with pragmatism in mind. Well, not explicitly mentioned, I am of the view that this would apply to other forms of correspondence as well as email. There are no separate DHSC policies for instant communication systems, and any instant communication application used would be subject to the information management policy and other applicable policies on IT usage, i.e. Not to be used, and that includes ministers. We then have the DHSC acceptable use of ICT policy, which is at page 285. And it starts at page 261, so page 285, organising information so that it's accessible, and if you can move through to page 261. Oh, did I say 285 instead of 258?
Can you just start the
I'm so
reference to
sorry.
this policy again so that I've got it?
I am very sorry, I've taken you to the wrong page. It's page 258.
Right.
It is the Department of Health and Social Care acceptable use of ICT policy. And I would like the court to look at page 261.
So this predated the policy that we've just looked at.
Yes.
Yeah.
And at 261, at the bottom, we have devices, systems and networks. The implementation of new mobile devices introduces a greater degree of flexibility in how devices are managed, with DHSC permitting the connection of DHSC devices to the department's IT infrastructure by Wi-Fi or another mobile connection from anywhere within the United Kingdom. And then if you can go down to, after the bullet points, to the words, in addition, users should only use systems, applications, software and devices which are approved, procured and with configuration managed by DHSC when undertaking official business, including work-related email, and apply DHSC standards and guidance in their use. Only use approved DHSC devices connected to the DHSC network when undertaking official business. And then the last bullet point, ensure no official information is stored on devices without DHSC security controls. That's important because implicit in that is that if you do have communications, you can't store your material on those devices. Insofar as it relates to government business, it has to come over to the DHSC approved repositories that were addressed in the information management policy. We turn next to a policy relating to those working in number 10 Downing Street, page 364. WhatsApp use on number 10 phones. Now this policy is actually of pretty recent origin. It was created, we can see, I believe, or it's not in dispute, it dates from March 2021. I'm not sure that's clear on the policy itself, but I don't think it's in dispute that it was a policy that originated in March 2021. And if the court will look at it and read through the whole of page 364, and then, so we see it's now available, WhatsApp, but only on number 10 devices, number 10 issued devices, and a very clear distinction between what it can be used for and what it can't be used for. It cannot be used to include any discussion about detailed policy or policy development, and obviously for security reasons confirming the PM's location. And if you find a chat unexpectedly developing into a more sensitive conversation, you should move the chat onto the number 10 IT system and continue it there. And then if we go to the bottom of the page, page 365, managing information. Staff are required to save a record of any conversation that should form part of the official record or otherwise may give rise to any Freedom of Information Act request, Public Records Act or similar data protection legislation requirements such as GDPR. Please see the Cabinet Office guidance on managing information, tasks and guides for more information on records management. And that's important because it does show, as all these policies serve, for example, the duties under the Public Records Act, they also serve transparency and accountability obligations arising under other legislation such as the Freedom of Information Act. It's not just the Public Records Act that is engaged in these. Cabinet Office owns all data on number 10 devices. This is at the top of page 386, including chats in WhatsApp. Number 10 may recall any number 10 device if required to search for a GDPR, FOI, or other data storage compliance purposes. So that is, if it's used on a number 10 device, it is the property of number 10. A breach of these rules will be subject to investigation and potentially disciplinary action that may affect your security clearance. So very, very clear that this is policy. You are to comply, and there are consequences that may potentially arise if you do not.
Those consequences are a matter of internal discipline, aren't they?
They are, but the point about those terms, my lady, is that, that it is a breach of something that is an obligation clearly stated that might lead to those consequences. And that's relevant to whether or not it is a requirement of this policy that you comply with it.
But it's an obligation imposed in the case of employees via the contract of employment, isn't it?
That is absolutely right, but the fact that there may be employment consequences does not stop this policy sounding in public law. That's the point. In order for it to sound in public law, we have to see what does it oblige the individual to do. And there are employment consequences, but there are also public law consequences, because this is a policy devised in the exercise of a public power.
Can I just ask you this, and it goes back to the question of remedies, which I know you said you'll come to at the end. But you're right, policies can be inward-facing, sometimes might sound in public law, but that's what makes it absolutely essential to know what the issue is at the start of the hearing, not here, but down below, with a clear relief. The government acted in breach of policy by doing X, Y, Z.
Yes, I can see that the fact that the Divisional Court did not look at and address the actual nature of the duties, the breaches, and whether there were breaches given the nature of the duties is a potential problem for this court. And if this court were to decide that the only way to deal with that is remission, then we wouldn't stand in the way.
But it goes beyond just what they did. It was what they were invited to. If one looks at the amended statement of grounds, it says plus declaratory relief, quashing orders, mandatory orders, like a confetti of orders that are there in public law, but without actually saying what you wanted and why.
Again, can I
come back to it?
come
Sorry.
back to that? Yes. I'm so sorry. I should be more on top of that, but I will need to look at that.
But before we leave this policy, does the paragraph under the heading Managing Information at the foot of page 365 recognise that there may be occasions where, despite the injunction about if the chat starts moving into something to do with policy, you should move to a different device, that staff may well end up having such conversations on WhatsApp?
Yes. So the starting point is don't do it, but recognising that this might happen in breach of the command not to do it, then let's make sure we capture the nature of those conversations by moving them onto a recognised government communication system. But the policy is don't do it.
So could somebody be disciplined for having such a conversation on WhatsApp and then moving?
My lady, it's not for me to go into the questions of whether somebody might be disciplined. That's going to be something that depends entirely on the facts. I'm concerned with what the public law implications are in relation to the terms of this policy.
But then the breach that you're perhaps alleging in answer to my lord is not putting it on to later, not putting it onto a government communication system. When?
Well, that's exactly the point. That's what we submit, that there is a requirement for proactive transfer of material. It's not simply let it sit on your device and wait for somebody to come and make a FOIL request, or let it sit on your device for 20 years and wait for the policy on the collection of public records to kick in.
I mean, this is my point about developing use of technology. You know, when WhatsApp began, people used it for very little things, and inconsequential communications. Then people began to use WhatsApp more. Then they began to use other programs. Then they began to take screenshots of things from WhatsApp. Then they began to do this and that. The whole thing is a very fluid situation, and there is great flexibility even in this modern guidance.
Well, there is not great flexibility in that this says in terms, and it is modern, absolutely, my lord, it is modern. It is March 2021. It was done and issued as a result of some of the use of WhatsApp that became public knowledge as a result of some of the leaks of Dominic Cummings, for example. And it is modern, but it makes clear in its terms, do not use private devices. We are going to issue, we recognise that there is now a new modern form of communication. We are going to let you use WhatsApp on your number 10 devices, but you're not to use it on your private devices. But it's also sensibly providing for circumstances where there may be breaches. And if there is, so there are two duties. One, don't do it. Two, if you breach or if there is good reason to use it, then make sure we don't lose the data. There are two obligations here, and we say that there have been breaches of both.
But why is that a matter for the court? Why isn't that a matter for internal discipline?
May I come on to that?
Yeah, sure.
There is the internal discipline issue, but then there is the question of whether or not that is unlawful as a matter of public law, just in the same way as a failure to comply with the policy that is touching upon the liberty of the subject is unlawful. It's the same question, and the question is to be answered by reference to what the purpose and justification for public law is, in part, and also what the case law says. So, but we'll come on to that. So we have, that's the DHSC acceptable use policy. No, that was the number 10 working...
But why isn't the availability of discipline under the contract of employment a suitable alternative remedy?
Can I come to that as well?
Sure.
Retention of communications and transfer. So
I mean, what bothers me is that seems to encapsulate the nub of your case now, but it's not in the grounds of appeal.
What encapsulates the nub of my case?
That there are breaches of both the obligation and obligation contained in policies specifically identified not to use private emails. We don't know what breaches precisely you're talking about, but we've seen the facts you record in your skeleton, and the breaches of an obligation to record the material. Sorry, you listen to me.
I'm so sorry.
That seems to me to be the nub of what you're now complaining about. But when I outlined the 4 issues that I saw from the grounds of appeal and the skeleton arguments, those are not... I mean, I know you say that in your skeleton as by way of background, but they didn't seem to me to be the nub of what we were here to decide. Now, if it's the nub of what we're here to decide, we're going to have an at least amended grounds of appeal. I mean, you know, this court cannot operate, Ms. Kaufman, on the basis that sort of allegations and arguments are thrown around in a discursive way. We do have to have some formality. You may call me an old, censorious old judge if you like, but you know, we have to have rules.
Indeed. So again, can I address that?
Yes, and it comes back, doesn't it, to the third source of power as well, because this is nothing to do with the national records.
No, but then nor is the security and government business policy. And that never has been. So it's never been part of our case that is.
Well, it's the divisional court I mean, that's the problem, really, is the divisional court dealt with the policy issue separate from the construction of the PRA issue. And what you appealed, I hate to go back to it, was that the policies are not enforceable as a matter of public law. That's all you appealed. And as to the facts, you only appealed the note, which you said was unlawful. The done note. So my lord keeps on asking you what relief are you seeking, and I'm just concerned that we're not clear what you're saying is enforceable as a matter of public law precisely, because we need to know.
So all the policies that I am going to take you through
Are all enforceable as a matter of public law?
Absolutely. That is a critical premise of our argument.
Right. Okay.
Every one I am taking the court to are enforceable policies.
And so if there's a breach of the policy and there isn't a justification for that breach, the court has to declare that X or Y is acted unlawfully. Is that it?
Yes.
Right.
I mean,
So
the ramifications, I mean, I hate to, if you're right, you're right. Don't get me wrong, if your argument is correct. But I can imagine that these policies are broken quite frequently, inadvertently, by lots of people in government, ministers, officials.
And in many instances, there's illegality in the conduct of governance on a daily basis. Most of the time it doesn't come out. One doesn't know about it.
Well,
but
don't we have to be a little bit careful about saying that the way the world goes round is illegal? I mean, the fact is that I started off by putting this to you. It's very difficult in the modern developing world for, let's take a minister, because obviously you're most concerned with ministers. For a minister, when the minister starts writing a WhatsApp message to a friend who happens to be another minister about dinner, to suddenly realise, I've also said we're going to discuss policy X at the dinner, so now that's got to be sent to a special place. And I shouldn't have written it on this phone, but I've only got 15 milliseconds because I'm about to go into another meeting. You know, what I'm asking you really is, can you confine the allegations of illegality so we can really grapple with them on a practical basis? Because, anyway, speaking for myself, I'm rather reluctant to declare a whole people's daily lives as simply being conducted unlawfully. Do you understand what I mean? I'm not being flippant about it.
I totally understand. The
Yes.
answer lies not in constraining the ambit of public law if public law should extend to policies of this kind.
Right.
The answer lies in the government addressing in its policies the practical difficulties and making policies that allow for this kind of communication, if that's what they think is appropriate. So it's for the court.
Jolly difficult, isn't it?
But it's for the court. The court is here to look as a matter of principle at the nature and scope of the public law duty of compliance, which exists, it unquestionably exists. The question for this court is, what is its nature and scope? Now, obviously, difficult cases are what vexes the court about which way to go. But here, there is a very straightforward answer. You don't, if principle dictates that policies such as these are subject to public law principles, then that is what this court should declare. And the problem is soluble by the government amending its own policies and amending them to reflect the reality, as they call it, of everyday life, or on the basis that there can be exceptions to any policy in any event. They may conclude that the exception rule, which is part of this principle, is sufficient to allow some such communications. But there are two aspects to this. There is the don't use and there is the record, where you do use on recognised government repositories. And there is no good reason why ministers, if they do stray into matters of substance, don't also proactively make sure that those records are transferred.
Well, Ms. Kaufman, I mean, I get all that, and I see the sort of black and white arguments. But courts have to be concerned with real life. And in real life, ministers and officials are very busy. There are not infinite resources. And one can see that mistakes will be made where there are fine distinctions, the one of which I suggested, let's have dinner at such and such a place at 8 o'clock, let's discuss this policy. That immediately then becomes, possibly, if something a little more maybe have to be said, but even so, it becomes recordable. Where does the minister find the time to record it? So it's quite impracticable for the reality is that's probably why a bright line rule was suggested at the beginning, which is that you don't use your own device and you don't use WhatsApp. But then your communication is handicapped for the modern age. So we're in this developing situation, and what I find slightly uncomfortable is that the court is being asked to sort of come down with its big hand and say, stop, this is all illegal, when what we're saying is illegal must go on all over the place every day.
But the court is saying nothing more than you have a duty to comply with your own policies. You implemented these policies in terms that requires compliance. It says so all over the place, so you expect compliance. Secondly, you did it to secure consistency, to secure transparency, to secure accountability. These are all matters that you considered in a carefully calibrated policy. Now, the answer is straightforward. If you don't like the result, change the policy.
Right.
But that is the answer. This court is not constraining by articulating this principle as having a wider application than the divisional court held it had. It is not constraining government action in formulating policies. It is giving effect to those policies. That's all it's doing.
And the issue for us is whether the divisional court was right to say these policies are not enforceable.
Exactly. That's the issue.
And the reason I'm putting to you the practical problem is that might be said to support what the divisional court was saying.
Well, in my submission, one has to be very, very careful when you are looking at general principles, because what you really are being tasked with here is to ask yourself a question of general principle and to focus on the difficulties arising in a particular case to decide that this principle has no application beyond the ambit identified by the divisional court is a dangerous course, because it ceases to be a principled decision and it becomes a pragmatic one. And that is not what this court should be doing. It should be looking at the principles and answering the question by reference to what those principles demand. And then, as I say, the government can get on and change its policy if it doesn't like it, or its policies. It's entirely up to the government. So can we come on to retention and transfer, just to make good the point that these policies don't just prohibit the use of private devices and mechanisms of communication, but also that they require any such use to be for the information concerning government business generated through those communications to be transferred to official repositories. We saw that already in the information DHSC information policy. Can we look at the Cabinet Office Information and Records Management Policy? That's at page 303. And this is addressed to all ministers and officials at the Cabinet Office. And if the court turns to page 304 in green, Introduction, Information Management describes the processes by which the Cabinet Office creates, captures, stores, manages, utilises and disposes of all information and personal data. We are required by law to create and maintain accurate official records of our work for the purposes of accountability and posterity. And then it lists at section 5 the legal and regulatory requirements, the statutory requirements that it is fulfilling by having this policy. Good information and personal data management helps us to comply with our legal obligations.
Now, section 5, sorry, where's that?
Section 5 is...
Is that 315? Because that doesn't look to be right.
It starts at 337, 336.
336.
because there are lots of 5s floating around in the policy, and I'm not sure which one you're on.
No.
There isn't a well, any policy review is 5 at 349. And then when you get into the appendixes.
Can we, as we go through it, can I see whether I can find section 5 for you?
Well, don't worry. So can you just give me the first reference you gave me, because I was trying to find that as well.
We're on page 305.
Right.
305.
Sorry, we're on page we're on page 304. Introduction. We just looked at the introduction.
Yeah.
We're going to go on to page 305.
I see. There are 2 information and records management policies. I was on the second.
Yeah, no, this is the Cabinet Office
Information and records management, not retention and destruction.
No. So, page 305, 1.1 purpose.
Yeah.
And at the second paragraph, the vision for Cabinet Office in relation to information and records management is for it to be a data-driven organisation where we are keeping the information and records we need to demonstrate corporate accountability. 3, we are maintaining an archive of historically important information. And 4, we can comply with our legal obligations. The purpose of this policy is to outline how information and personal data should be managed, all information and records management practices and any other policy relating to information management in the Cabinet Office are to be in accordance with this policy and its supporting procedures. If we can go to page 306 and 1.2, if I can ask the court to read down to 1.4, you'll see some of the legislation there mentioned that it complies with. And then 3.1 on page 309, defining and capturing records. Records are defined by the Code of Practice on Records Management issued by the Department for Digital Culture, Media and Sport, Secretary of State, as information created, received and maintained as evidence and information in pursuance of legal obligations or in the transaction of business. They can consist of any format or media type, including both electronic and paper formats. Records may be formed of any information and may be either an individual document or a collection of documents or pieces of information which may be stored in one or more systems. Examples of important information include non-exhaustive, 4th bullet point down, submissions to senior civil servants and ministers, their responses and the replies from their private offices, and then 5 down from there, committee papers, minutes, summaries of recording or recordings of meetings, reports, etc. And second from the bottom, internal memos, business discussions with colleagues. And then 3.2 on page 310, approved records repositories. Information and records will only be stored in approved repositories in accordance with departmental security policies and held in appropriate formats or systems based on their security classification. And then at the bottom of that paragraph, where you have the underlining and emboldening 3 lines from the bottom, non-authorised repositories must not be used, including personal email, and the DRO must be consulted at an early stage of any technology change that will have an impact on information and records. And then 3.313, paragraph 3.7, I'm sorry, retaining records. And if the court can read the whole of that down to the last subparagraph with the blue writing, not including that. And that makes clear that, again, this is made for the purposes of securing compliance with the PRA. Then Sarah Harrison, in her witness statement, addresses this policy. Her statement starts at page 105. And page 127, paragraphs 88 to 91. She addresses this policy, and if the court can read down to paragraph 91.
From paragraph, sorry?
From 88 down
Thank
to
you.
91. 88 on page 128. And you can see at paragraph 90, she's referring to the Information Management Standards Framework, which refers to the need to save important messages, including all electronic messaging systems. And she explains at 91, saved in this context means that any important messages that need to be retained for the record must be identified and moved to an official repository. And then paragraph 112, which is on page 135, she addresses the number 10 policy that we've just looked at. And just ask the court to just read paragraph 112.
Sorry, you say the number 10 policy impact the Cabinet Office Information and Records Management policy?
Yes.
Because there's a
I'm
number 10
sorry, yes,
WhatsApp
this
policy.
is what happens, yes, this is the effect on
Yeah,
number 10.
I understand
Exactly.
that, but there are so many policies floating around.
I'm sorry.
I just want to be
exactly.
accurate.
This is the effect of this policy on number 10.
Yeah, thank you.
And so they are equally expected to make the transfer of those records onto the authorised repositories.
Which is a Google Drive.
And you will have seen from paragraphs 88 to 91 that Ms. Harrison is also making clear that the whole record should be transferred. So this was in answer to one of your lordship's earlier questions. This policy requires the record to be moved. So, Cabinet Office Information and Records Retention and Destruction Policy. That is a policy that applies to Cabinet Office in number 10, page 336.
That last policy was dated February 21, is that right?
This policy now that we're looking at is dated February 21.
So was 303.
And the other one.
So they were both produced together.
And recently, which is not insignificant for the reasons that we've just addressed. Paragraph 1.
Will they refer to each other?
Yeah. And paragraph 1, the Cabinet Office needs to operate and act efficiently, demonstrate accountability, comply with current legislation, and manage its information content appropriately. And paragraph 1.1, if the court can read that.
third sentence of the second paragraph doesn't seem to make any sense.
Third sentence of the second paragraph.
Under paragraph 1.1. Records deemed to be of important historical interest, and this applies equally to information held in paper and digital formats.
No, that doesn't make any sense. I think something's been missed out.
Looks like it.
Yeah. Records, the following sentence makes sense, and the rest of the paragraph don't make sense. I think what's missed out is it should be kept.
Well, it might be just records are deemed to be of importance. Maybe the word "are" is missed out.
It could be R or...
Who knows?
Then if we could look at 1.3, and the first paragraph in 1.3. Then 1.4, scope. This retention and destruction policy applies to all information held in all systems at all security tiers, security classification, including, if you go to the bottom, the last bullet point, including repositories that are not managed by the department but are used by ministers and employees for business purposes. And then the audience, you can see who it applies to, all Cabinet Office staff, ministers and special advisors, and so forth. And then at the last bullet point, data created outside Cabinet Office systems, created by staff and ministers for any business reason. 1.6, statutory and other legal requirements. This policy complies with the applicable data protection requirements within the following legislation and regulations: Public Records Act and the Freedom of Information Act we see. And then at 2.1 on the next page, general approach. In general, information will be retained for 7 years from the date of creation or capture before it is first reviewed. And then we go to 4.4, email boxes. Staff are required, that's on page 347, staff are required to identify emails required for the departmental record and ensure they are appropriately filed in the relevant team shared drive. Individual email accounts must not be used for long-term record storage. 4.5 and 4.6, instant messaging and text messages. Can I ask the court to read those two paragraphs? These are all concerning the use of official devices and those particular messaging apps on official devices.
I mean, I know I've been on about this, but the problem is deciding. I mean, I'm just thinking of my own position. When you start writing something to somebody, you choose the method of communication, and you've really got to be very efficient, to be absolutely right, to know exactly what you're going to say. Because different rules apply to instant messaging, text messaging, email messaging, WhatsApp messaging, signal messaging, and so on. So it's expecting a sort of a person subjected to these rules to be either have lots of time or to be very, very clear about what they're doing in every message. And realistically, of course, there will be mixed messages, if I can use that term in an unconventional way, where you're writing about one thing and then you verge on to writing about another, particularly if there's a quick exchange. So it's I mean, I'm just pointing out, just makes it all quite difficult, doesn't it?
On my reading of the policies, it's not that difficult if you follow what it's requiring of you, which is don't use your private devices.
Well, use
Insofar as
a
you've
public
been-
device, and basically if you use email, then you're safe because it's all recorded.
It's all recorded, and if you're using other forms of messaging, then if you're going to use them and you're going to stray into, and this doesn't tell you that you can or
But
cannot.
Sir James
stray.
says that's all very impractical because people actually are people and they use what's available in the modern world. So
And that's-
if you accept that premise that I think Sir James's argument entails, that people will use different methods, which this policy accepts,
What,
then it gives rise to the problem I've indicated.
what this policy facilitates is the use of those methods, but within authorised government systems. So
Yeah,
that
no, all I'm
security
putting to you
policies
is,
can
I mean,
apply.
I understand that, but all I'm putting to you is even within a government system it gives rise to difficulty, because when you use instant messaging, which is going to be deleted, if you're using instant messaging and you suddenly find you're talking about policy, you've got to spend more time repeating it on another method. I mean, it's just difficult, isn't it?
Yes, but because it can in some cases be difficult, that is either recognised in the policies themselves and they take account of those difficulties and the policies are changed. But it's not a reason for the court not to apply.
But this is what I'm
public
putting
orders.
to you, Ms. Kaufman, is that this is indicative, because it may be so difficult, that the divisional court might have been right to say this is not a question for this kind of policy is one that should not be regarded as enforceable because it gives rise to so much difficulty. Now, you say the policy's got to be so clear and so clearly adhered to that it is lawfully, legally enforceable.
Yes, and then the court has, within its panoply of powers, ways in which it can make sure that it doesn't act unjustly. For example, relief and standing are ways in which it can shut out cases where precisely that sort of difficulty arises.
I was going to say, won't there be zillions of cases like this?
Well, in all likelihood not, because in all likelihood it will not come to light that there are such communications
Well,
going
that's
on.
not a good reason. I mean, it's not a good
Well, it's-
reason to say it's in the shadows and therefore...
Well, no, it's just a matter of reality. The question you just posed is, aren't there going to be millions of cases like this? And
you
the answer
say no
is,
because it won't come to light.
there won't be, because we won't know. We do happen to know, but one has to think about how these communications arise. And that is, they arise between individuals who are not exposed to the public eye unless somebody decides to disclose those communications. So they will not come to light. But that's also one reason why, if the law does apply in this context, the court should say so, because if the law requires compliance subject to good reason not to, that is a further important reason on top of the commands within these policies themselves that there should be compliance.
May I just ask you a couple of questions, please, about the legal framework? Would you accept that the guidance that we've looked at, which has the little logo from National Archives, is guidance which is issued under Section 3.2 of the 1958 Act?
Yes.
So every person who's got duties under Section 3.1 is to perform those duties under that guidance.
Yes.
Right. Now, 3.1 requires every person who's responsible for public records to make arrangements for the selection of those records which ought to be permanently preserved and for their safekeeping. Would you accept that the other policies that we have been looking at are arrangements under Section 3.1?
That's absolutely our case. We
Right.
submit those are arrangements. The divisional court said they're not.
Right. Just want to be clear about that.
Yeah, we submit they are. Divisional court said no, they're not.
But if they are arrangements made under Section 3.1, would you accept that they are the way in which those people have chosen to comply with Section 3.1?
Indeed. The question then is, are they enforceable policies?
Well, no, wait a minute. So So they are arrangements under Section 3.1. Are they lawful arrangements under Section 3.1?
Well, we certainly don't challenge their legality.
Right, that's very helpful. Thank you.
No, we don't challenge their legality at all. Quite the contrary, we submit they are lawful and they are enforceable. So,
Even though they're just arrangements.
well, the guidance, so an arrangement is expressing itself in the form of a policy. The question then becomes one of the application of administrative law principles as to what the status of that policy is.
I see.
They are arrangements which, formulated in terms of the policies we have seen, constitute a policy which those to whom those policies apply are required, or whose terms those to whom the policies apply are required to comply.
But if the policies are lawful ways of discharging the Section 3.1 duty, where is there any room for a breach of the Section 3.1 duty by the people to whom Section 3.1 is addressed?
We aren't arguing there's a breach of the Section
Right.
3.1 duty. That's no
Right.
part of our case. Our case is they are arrangements made pursuant to Section 3.1. They are arrangements in the form of a policy. The principles of administrative law apply to policies such as
No,
this.
I've got your points about the policy. I just want to establish where this all fits within the statutory framework. That's very helpful. Thank you.
So we then come on to the DHSC Information Management Policy. Which is dealt with, I'm sorry, ignore that, we've looked at that. Finally then, we come to the Cabinet Office private email guidance, and that is at page 232. We can see paragraph 1, guidance to departments on the use of private email. Now this was issued in 2013.
It's a jolly long time ago.
It was issued a long time ago. And it says government information must be handled in accordance with the requirements of law, including the Official Secrets Act, Freedom of Information Act, Data Protection Act and Public Records Act. Paragraph 2, there is a wide range of communication tools, both formal and informal. This guidance principally deals with emails, but it applies equally to other forms of communications and records which deal with departmental business. So that would be WhatsApp, Signal, all the modern forms of communications. It should be read in conjunction with the Information Commissioner's guidance on holding information, official information, held in private email accounts. And we will look at that in a moment just for completeness. Paragraph 4, management and storage of records. If the court could read paragraph 4.
Is there a Lord Chancellor's Code of Practice anymore, or has that been superseded by something?
We believe there is.
Right.
But not in the bundle.
It's not in the bundle.
I think the position was that the Lord Chancellor used to have certain responsibilities under the 58 Act and doesn't anymore. Is that right?
No, the Lord Chancellor still has some duties somewhere. I've seen them. I'm not sure where.
So, okay, so that exists, but we don't know where it is.
The key part is halfway down. The responsibility for deciding whether emails should be retained rests with the originator and recipient. In general terms, a record need only be retained if it is needed for substantive discussions or decisions in the course of conducting official business. Ephemeral, last sentence, or trivial emails need not be retained even if generated in the course of conducting government business and should be deleted on a routine basis. So that's the judgment call that people have to make, my lord, the master of the rolls, is which side of that divide does it fall on? But if it, in my judgment, falls on the conducting government business side of the line, then it needs to be saved. So use of government email systems for government business. This is at 7. Civil servants and ministers are generally provided with access to government email systems. And then this sentence, which is important in relation to done and the done note that we'll come to later. Other forms of electronic communication may be used in the course of conducting government business. Departments' security policies will apply when generating and communicating information. So just looking at those two sentences, question 1, or key question, does the use of the word may there indicate something that is permissive, it's permitting the use, or is it simply describing what might happen as a matter of fact? And our submission is that it is the latter and not the former, and that is precisely because of what follows. Department security policies will apply when generating and communicating information. Well, we know that security policies prohibit the use of private communications. So it's impossible to read those two sentences together if the first sentence is permissive. The originator, and this is the last sentence, the originator or recipient of a communication should consider whether the information contained in it is substantive discussions or decisions generated in the course of conducting government business, and if so, take steps to ensure the relevant information is accessible, e.g. by copying it to a government email address. And then paragraph 9, the Freedom of Information Act and searches for information. Freedom of Information Act.
Sorry to interrupt. Can I just ask you about the last comment you made on 7, which
Yeah.
was the department's security policies will apply when generating and communicating information. In relation to that, which one are you say you know that the security one says that they can't use private ones. Which security one are you referring
So
to?
we've got
Is that the
security and
SGB?
government business, for example.
The SGB one.
The SGB one, and then also we know that SGB applied to BEAS as well. That was a reference I took you to earlier. I can give you that again, but that was specifically applied to BEAS, to the Department of Business and Enterprise.
Yeah.
So these provisions prohibit, and we also have seen some of the other provisions prohibit it. So it's clear that it's simply descriptive of what might happen. And if it happens, that's what you've got to do. And then we've got 9, paragraph 9, which refers to the Freedom of Information Act. The Freedom of Information Act allows people to request information, and then the following sentence at the end of line 2, it is for the department to consider where the information might be and to take reasonable steps to find it. As set out above, it is expected that government business should be recorded on government record systems. It will generally be reasonable to search only within those systems when a request has been received, i.e., consistent with the duty to transfer records. That's where it's reasonable for us to look, because all those records should be on the government system. And we submit that that is entirely consistent with what we say is required by these policies, insofar as they deal with retention, which is that the retention requirements, the storage requirements, are for proactive transfer from the repositories where they are, where the information originates, into repositories for storage. So those then are the policies, and we submit that those policies are, for our purposes, have 2 particular effects or requirements. One is that there is a duty not to use, in the conduct of government business, private systems and communication devices. But that if...
Sorry to interrupt. Can you just tell me where you take... Because you've not put this down as these are breaches on this date, so this is very helpful. So there's a duty not to use private systems and communication systems arising from which policies are you saying?
So
not
those,
just all of them.
Those are identified in our skeleton arguments, so I will give you the references in the skeleton argument for exactly where those are.
That's extremely helpful.
Paragraph 13.
Paragraph 13.
We deal with the 2. So paragraph 13 identifies the duty not to use, and paragraph 13A and 13B is it?
14 is
14 is retention.
So it's the SGB.
Sorry, it's... Yeah, so 13 deals with not to use, and it's all those policies set out there. And 14 deals with retention.
Well, hang on. If you look at 13.2, I don't know, the numbering goes a bit funny
It's gone
because it goes 1,
crazy,
6, and
hasn't
then
it?
2.
Yeah.
It doesn't matter.
So 2
But
after
if you look
6.
at 13.2,
Yeah.
that is the Cabinet Office Information Records Management, which says non-authorised repositories mustn't be used. That's perfectly true, but it doesn't say don't use private emails, because otherwise you wouldn't be talking about having a repository there. That's why I wanted
Yes, I'm
the
sorry.
specificity.
I think that's why we've got the funny numbering, because that 2 seems completely out of place there, doesn't it?
Well, so does 6
That is a
if
repository.
one's being brutal about it.
And 6 is as well, yeah.
I'm not here to criticise the
I'm
number.
sorry,
What I'm here
let
to
us correct that as well, and bring for your a note tomorrow to identify each policy that prohibits and each policy that is concerned with retention.
Can I then also just give you this fair opportunity to deal with what really concerns me? Because you've said policies are important provisionally. I entirely understand and agree with that. You also say that therefore the court shouldn't back away from their constitutional duty. I really do understand that. But that means that it becomes absolutely vital for claimants coming to court, straying into general policies impacting the important work of government, to specify what they're complaining about at the start. And the courts do have powers, one of which is a discretionary one, to say, you didn't do it at the time, tough. And when you do your note on remedy, I, for myself, would find that very helpful to have addressed.
We will make sure we will do that as well.
Thank you.
I do apologise to the court for my omission. Can I turn then quickly to exactly what we say by way of breach of those policies? So, so far as use of private systems of communication and devices is concerned, this is documented in the respondent's own witness statements. It's accepted that there have been many instances in which this has happened. And that isn't in dispute at all. And I'm not going to, the court has been asked to read those statements, and I will take it that the court has done so, or will be able to do so after the hearing. I haven't got time now to go through all the evidence, but can I just give a flavour to the court of some of the instances of both use, contrary to the prohibition on use of such devices and communication mechanisms, and the second kind of breach, which is the failure to transfer the data arising from those communications to authorised repositories in a proactive way, which we say are the requirements of the policy. So, can I give examples of use by the Department of Health and Social Care? So, this relates to use by Matt Hancock when he was Secretary of State for Health and Social Care. And this is addressed by William Vinell in paragraphs 10 and 11 of his witness statement, which is in the bundle, supplementary bundle, page 39. Mr. Hancock's statement, so this statement comes from other litigation. So what we have is a summary of the statement of Mr. Hancock in other litigation. Mr. Hancock's statement, between paragraphs 5 and 10, says that he used the following accounts for communication during his time as Secretary of State. And we can see his WhatsApp account at B connected to the mobile telephone number for his personal device, his private email account at C, direct messages on his Twitter account, and at E, SMS messages from his personal device. And at 11, the last line in 11, I also understand that a single WhatsApp account was used by Mr. Hancock. At paragraph 14 14, you can see those devices, email accounts are also listed in paragraph 12, and there are some private email accounts. And then at paragraph 14, if the court can read paragraph 14, where he says, my main form of communication of government business was my departmental email account. My main form. Now, it necessarily follows from that he did use other non-government accounts to deal with government business. So we can look now at one example of important government business that was conducted on a private WhatsApp group. Now, these documents came from the Gardner litigation that the appellant was involved in, and that was a successful challenge to government policy on the transfer of patients from hospital to care homes during the early stages of the COVID pandemic. And it was a challenge brought in light of the government's growing appreciation of the risk of asymptomatic transition, something we all no doubt are well aware of, and the huge number of deaths that then resulted. In the supplementary bundle at page 381, we have the transcript of that hearing. I hope that there has been yellow highlighting on this for the court to be able to be directed to the relevant passages.
Yep.
If the court could just quickly review those yellow passages. Now, it's notable that Sir James himself was referring to some of these WhatsApp communications in relation to these proceedings, and that there wasn't any reference to anything other than these communications recording the same information. There's no reference to any government or this information by reference to authorised government repositories into which it had been transferred. And
well, how do you think they got them?
They were...
Because
so they were provided by Ms. Watley, the Minister for Social Care. They came from her device, and we can see communications, the actual communications that follow at page 387.
387.
There are communications that follow at 387, and then there are communications that follow again from Helen Watley with Matt Hancock at 392.
So you say these came not from government disclosure?
Well, they came from government disclosure.
Right.
But how they were obtained,
yeah.
So not from repositories to which they had been transferred in advance of the litigation.
And where do we get that from?
Well, I'm going to come on to that in a moment, because we get it from the response to our request for further information, and I will come on to it.
Okay, that's fine.
But they were, as one can see, important communications relating to grave matters of public interest in the conduct of government business. And that is also clear from the communications on page 392 with Ms. Watley and Mr. Hancock, where there is a discussion about social care and the needs of the part of the department for which she was responsible, particularly in relation to finance. And we know that these only came to be transferred into the hands of the government in the course of the litigation and because of the litigation. And the reason we know that, as I say, is because of the request for further information that we made. Now, if you can turn to request 5 on page 5.
So page 5 of what?
Page 5 of the supplementary bundle. This relates to the statement of Mr. Finer. I'm told that Mr. Hancock and Mrs. Watley did exchange some WhatsApp messages relating to the discharge of individuals from hospital into care homes. These WhatsApp messages are on the government system and have been disclosed as part of the Gardner litigation. Please confirm when each of the messages was transferred to the government system and by whom, whether each message was transferred to the government system for record-keeping purposes or for the purposes of the litigation. And the answer to that is in answers 8 and 9, paragraphs 8 and 9, on page 10 of this same bundle. As to the request at 5A, they were transferred onto government systems by officials following their provision by Mrs. Watley to officials in August and October of 2021. So you saw the dates. This was in early 2020. And then we can see quite clearly the basis upon which they were transferred, and that's at 9, information, they were transferred for the purposes of responding to, some for the purpose of responding to the Information Commissioner's investigation, and some for the purposes of the Gardner litigation. And in relation to Mr. Hancock, those provided by him and transferred to the government systems were solely provided for the purposes of the Gardner litigation. So no proactive transfer of any of those records. Can I then turn to the Abingdon litigation? Actually, before I do that, I'm going to turn to the Dominic Cummings WhatsApp leaks that I mentioned. Now, the nature of those WhatsApp communications are set out in our amended statement of facts and grounds at paragraph 36, pages 302 to 305. If the court hasn't already read them, could I ask that the court note those and read those in your own time? Again, plain that they concerned substantive discussions in the very early days as the pandemic was unfolding, in relation to matters such as PPE, in relation to matters such as testing, in relation to matters such as whether or not legal obligations were going to be complied with respect to procurement. None of those important messages had been transferred to a government communication system. And we can see this from the answer to our Part 18 request of the 21st of February, paragraphs 1 and 2 on page 6 of the supplementary bundle. The court can read paragraphs 1 and 2. The answer to those questions is in paragraph 6 of the 25th of February response on page 8. We can see that says the answer to request 1 of the 8th of February is repeated. So if we then go up to page 7, we can see request 1. So the answer is clear. None of the messages in issue have themselves been transferred to a government communication system for recording as a direct record. Rather, where a message conveyed a policy indication or steer, the substance of such messages is relayed to and recorded by officials where appropriate. A policy indication or steer. Well, that's not what the policies required that we have been looking at earlier today. They required transfer of the messages. They required transfer of information more extensive than a policy indication or steer, or where they may result in commissioning of formal advice or submissions from officials. So, and then, so far as the Abingdon litigation is concerned, that is another instance, and perhaps the best way to deal with it is that when we then provide you with our summary of areas of breach, my lords and my lady, I can identify our concerns in relation to Abingdon. I'm just very concerned about the time. Does that...
Yes.
I'm grateful. So, in our submission, that evidence, those are evidence of instances where there has been breach of the policy insofar as private devices and private communication mechanisms are used. That's all set out in the defendant's own evidence and accepted. And in our submission, there's been no good reason offered for why those communications occurred. And secondly, breaches, insofar as they did occur, of the duty to then make sure that the public record was maintained in respect of those communications insofar as they related to...
Well, is there any evidence about the second part at all?
There's only those responses to the RFI requests.
Will they just say, what, they weren't on the government system?
Yeah.
But, yeah.
So, can I then turn, just before the lunch adjournment, to the source of the power under which the policies were made? So, all those policies, bar the security and government business policy, are ones which in our submission were made pursuant to section 3.1 of the Public Records Act. They were arrangements for the purposes of that Act. If we could turn up the Public Records Act, it's the first authority in the authorities bundle.
So, first authority, that's easy.
I'm sorry?
The first authority, that's easy.
Yes, it's authority number 1.
Public Records
And it's
Act.
page 7.
Yeah, the Public Records Act really is extremely unhelpfully recorded here without major sections. I'm using it online where I can see the whole of it rather than bits.
Would your Lordship like us to provide a...
I would like always to provide legislation, particularly short legislation of this kind, in its entirety, not selected highlights, particularly when major sections are omitted.
My Lords, we'll do that and we'll provide it electronically.
I'm not being dictatorial, Ms. Kaufman, but it's for future reference.
We will make sure that we do that. So, can I ask the court to read section 2?
Why not read section 1 first? I mean, you know, section 1 does help your case.
Yeah, unfortunately, it's not a section that is in the bundle.
No, it isn't. That's the part of the point I was making. But can I just read it to you?
Please do.
Just in case you think it's important. Section 1.1, general responsibility of the Secretary of State for public records. That's the Secretary of State of the DCMS. The Secretary of State shall be generally responsible for the execution of this Act and shall supervise the care and preservation of public records. Subsection 2. There shall be an advisory council on public records to advise the Secretary of State on matters concerning public resource in general, and in particular on those aspects of the work of the Public Record Office which affects members of the public who make use of the facilities provided by the Public Record Office. You may think I'm interested in this because the section goes on to say the Master of the Rolls shall be chairman of the said council, and the remaining members of the council should be appointed by the Secretary of State on such terms as he, or really she, may specify. And then the Advisory Council may advise on matters including the Freedom of Information Act and lay a report before Parliament. So that is the guiding section to Section 2, which then you're going to come on because you've got it.
So if the court then could look at Section 2 and read through subsections 1, 3, 4, A and B particularly.
Yes.
Well, 4's not really relevant to the issues in this case, is it?
No, but it gives you an indication of the fact that members of the public are going to be able to look at the records and therefore something as to the purpose.
Well, the whole purpose of this Act is to make for public consumption government records, make them available at an appropriate time. And it used to be after 30 years, and we all know that recently it was reduced to 20 years. And that's caused quite a lot of difficulty in government departments because they got used to doing it after 30 years. And of course, that spanned a period in which digitization occurred. So the difficulty now is they're now presenting for retention digital records from 20 years ago and up to say 25 years ago. And when they reduced it from 30 to 20, that suddenly brought in great chunks of digital records. So that's what this is all about, is to get this material into the public domain at the National Archives and available to the public for historical and research and every other kind of transparent purpose.
I'm grateful. By
This is slightly dear to my heart, as you may understand, because transparency, openness, and the National Archive is a very important public function.
And we would absolutely endorse all of that.
I'm sure you would. And this is the section that gives the keeper very great powers to make sure that the right records are brought in for public preservation.
Precisely.
And you may or may not know that I, as Master of the Rolls, am responsible for manorial records. That's historical records, which is an absolutely fascinating subject we won't bore you with now. But actually the question, people talk about public records and they glaze over as if it's something incredibly unimportant. But we have in this country the most complete record of our history of almost any other country in the world. And we should be proud of that. And it's through this legislation and what went before, which did involve the office I hold, that it exists. And all this is doing is codifying how this is to happen with the keeper taking charge, and it gives you his duties. And then you come to the very important one. We've read 2, you come to 3, which is absolutely critical, of course.
Yes. So that is an obligation on him in subsection 3 to take all practical steps for the preservation of records under his charge.
Yes.
That means records in queue, doesn't it?
That's how I read it. Once they are under his particular charge. So what we're concerned with, how do they get under his charge? And one of the obligations on those whose records they are and who are generating them to ensure that the records that are necessary for preservation and a complete historical record in the interests of transparency and openness actually get there. And that's the key question as to what does Section 3 mean, Section 3.1 in particular. Does Section 3.1 in particular, and that's the critical section, and if I'll ask the court to read it again, and section 3.2 together, and section 3.4, if you would, because that gives important context.
But you do have to deal with my lady's point that all this guidance that comes from the National Archives and the keeper in particular is fairly clearly, I mean, subject to what Sir James says, because the divisional court said that only one of the three pieces of guidance you rely upon were statutory guidance under section 3.2. You've submitted they all are, and I understand that submission, but I don't want to prejudge what Sir James is going to say. But if it is guidance under 3.2 given by the keeper, it's a little harder, isn't it, to say it's unlawful not to follow it. I mean,
We are not relying upon guidance issued by the keeper.
Yes, you are.
As opposed to, well, we're also relying on 3.1 guidance issued. That self-same guidance is also issued by a government department.
Well,
so it is both.
That you can't distinguish. That you must distinguish. Forgive me. 3.2 guidance is to help the Secretary of State or the person responsible for public records of any description which are not in the Public Record Office to perform their duty under 3.1. So the keeper is giving guidance as to how the person who's responsible for public records, in other words, public documentation of any kind, shall do their duty, which is to make arrangements for the selection. And so that's in the 20-year period before they are deposited at the National Archives, those that are ultimately selected. If you can imagine, our government ministries have massive repositories of data. I mean massive, hundreds of millions of records. And from those hundreds of millions of records have to be selected those that are suitable for ultimate retention. And this section is aimed at that process.
Well, that's precisely our submission.
Well,
the position of the divisional court was this, that the arrangements that are contemplated in section 3.1 are simply arrangements for the ultimate selection for preservation.
Yeah, that may or may not be right. I mean, I understand what you're saying. That may or may not be right. But the point is the guidance of the keeper is to ensure the person under 1 can do their duty in making arrangements for selection. Now, whether selection is so narrow as it only involves the process after 20 years or wider is the issue, I understand, between you and Sir James. But I'm just saying this section has to be read together, and the guidance that we're looking at, that the keeper issues, is guidance under 3.2. Now that, I think, is uncontroversial.
Well,
it may be
I'm
controversial.
sure it's uncontroversial.
Well, it may be controversial in the sense as to which guidance, but it's not controversial that there is some guidance.
Absolutely. So, for example, the very first piece of guidance that I took your lordship to, I don't think there's any controversy that that's section 3.2 guidance. But the guidance that was a joint publication
that's controversial.
That is controversial.
Yeah. All right. Can I just ask a further question? Assuming you're right and both sets of guidance are issued under 3.2, is it? I just want to be absolutely clear about this. It isn't any part of your case that any of that guidance has been breached. Is that right?
The 3.2 guidance.
Yes.
The Cabinet Office guidance issued together with my brain has just together with the keeper.
So you're saying there's been breach of the joint guidance, but not of the set of guidance that's been issued by the National Archives?
No, because that set of guidance from the National Archives is really identifying what public records are. That's the purpose which I was.
Right. So there's no breach of that guidance.
So no.
But you say there is breach of the joint guidance, which is very specific. joint guidance.
Yes.
There has been breach of that, you say. Yeah. Okay, well, look, it's 2 minutes past 1.
2 minutes past 1. I have a lot to get through.
Okay, well, we'll try and shut up. We've not been that good, but we've not been that bad by comparison to some cases. We'll resume at 2 o'clock.